This is going to be the playbook going forward for gun grabbers. We are the Armed Attorneys. Today we're talking about a court up in the Northeast that upheld a magazine ban. Now, this is significant. This is one of the first bans we've seen upheld in the wake of the New York State Rifle and Pistol Association v. Bruin case. Now, there's a whole lot to this, so you won't want to miss it. But before we begin, show your support for the Second Amendment by hitting that like button. Today's video is sponsored by our friends over at Core Essentials.
Core Essentials makes the best fitting, most comfortable gun belt you'll ever wear. What makes them so unique is a hidden track system with over 40 micro-sizing positions to adjust. This means you'll have the ability to precisely adjust your belt, tighter or looser, in tiny quarter-of-an-inch increments to get the perfect fit.
The result is the belt keeps your holster and firearm as close to your body as possible without snagging or flopping around, so you can run your gear with confidence and comfort.
Check out their full collection of incredible carry belts at www.coreessentials.com.
Thank you to our friends over at Core Essentials and for making this content possible. Show them some love. Now, today we're talking about this court up in Rhode Island that found this magazine ban constitutional.
Yes, so what we have is a statute passed by the Rhode Island legislature. You can find it at Rhode Island General Laws 11-47.1-2. And essentially what we've got is a ban on, of course, what they call high capacity magazines, but it's a ban on magazines that are capable of accepting more than 10 rounds of ammunition. There is no grandfather clause in this ban. So if you own any magazines that can accept more than 10 rounds of ammunition, by December 18th of 2022, so that's this week, right?
Yeah.
You must either convert that magazine so that it can no longer permanently ever again be capable of accepting more than 10 rounds of ammunition. Or if you don't want to do that or cannot do that, you must either sell the magazine to an FFL dealer or turn the magazine over to law enforcement. That is the specific methods of dispossession that are written into the law. There's no sort of self-destruction written into the law, anything like that.
But, as you can expect, the gun community up in Rhode Island didn't take this laying down, led by a gun store and some individual plaintiffs, and they challenged and sought injunctive relief. Hey, we want to keep this law from going into effect on really three different grounds. One, hey, this violates the Second Amendment. Next, this is an unlawful taking. And third, that their substantive due process rights were violated under the 14th Amendment. So we saw this challenge going in. The courts evaluated. This was actually a very long opinion for everything that was covered. But you can tell that this was an Obama appointee judge, and some of the kind of graphic and brutal language that they used when discussing the Second Amendment. And ultimately, the judge did not grant the temporary injunction, saying this law was constitutional. This didn't violate the Second Amendment. In his opinion, he thought that this would likely be upheld by the Supreme Court, and he kind of skirts his way around the New York State Rifle and Pistol Association v. Bruin case.
Right. So, let's back up and break that down a little more carefully. So what we've got is when you believe that a law is going into effect that is possibly unconstitutional, you want to have a court grant an injunction so that that law does not go into effect. And in order for the court to grant an injunction, you have to show a couple things. You have to show a high likelihood of success on the merits. So basically, the court has to say, all right, I'm not making the determination now, but when ultimately I have to make this determination, or a jury has to make this determination, I believe that this side is going to win. And if I believe your side's going to go ahead and win, then I will grant you the injunction. But if I think your argument's a loser, I'm not going to grant the injunction. There are a couple other things. There is the irreparable harm if you do not grant the injunction. And then there's just sort of a public policy argument. And this judge really, he cut all three of those against the plaintiffs here. He said, essentially, you don't have a likelihood of success on the merits. And
Right.
we'll talk through why that's coming in just a moment. He said that there is no irreparable harm here, which I think is crazy because we're talking about
Thousands,
property.
tens of thousands of individual pieces of property.
Right. We're talking about property that you either have to get rid of or permanently alter. So that seems crazy to me. But he says, no, no, no. And then finally, the public policy arguments, of course, are all, obviously people can't murder other people if they only have 10 round capacity magazines. Right, Richard? That's essentially what he's saying.
Yeah. The judge went and listed every mass shooting, how high profile mass shooting we've seen in the last decade, and caps it all off with this seems like a reasonable restriction.
Exactly. Public policy does not favor not letting this law go into effect.
But I think what is so fascinating about this decision, and this is going to be the playbook going forward for gun grabbers when they pass new legislation that affects our ability to defend ourselves, carry what we want, and this is the key part: have the accessories that we want, because this is how they're going to try to sidestep the argument in New York State Rifle and Pistol Association v. Bruin, because the judge here basically said magazines don't implicate the Second Amendment.
Magazines are not arms.
Yeah, and so I mean, that is, I mean, that's one way to get around it.
Right. And so because he finds that magazines are not arms, they do not, saying that you can only have certain magazines does not violate the Second Amendment, does not therefore implicate Bruin. And so he doesn't even do the historical context and analog analysis because he says, I don't have to. This doesn't implicate Bruin. It doesn't matter what the laws were in 1791. It doesn't matter because this isn't a Second Amendment issue. Again, interesting.
Right.
The best argument they have, as annoying as it is, I mean, because once you have to argue on Bruin grounds, you lose. You lose if you're trying to institute gun control. And so this is the best they've got. And if it works, that's how we're going to get new gun control laws, right?
Yeah, and this would be an absolute shame if the United States Supreme Court doesn't get this court into line, because we're going to see this all over the place. But essentially, what they're going to be saying is everything that's not the firearm, not the arm, would not be protected by the Second Amendment. So think about all your accessories. Do you need a pistol grip to have a firearm? Do you need to have an optic? Do you need to have this, that, and the other? That's what they're going to argue.
Exactly. So, I mean, the other issues that we talked about, of course, they challenged not just on Second Amendment grounds. The judge did not buy the takings argument. Essentially he said it's not an unconstitutional takings because we're saying you can sell it back to, an FFL dealer, or you can convert it, you still have it. So therefore, the government isn't taking anything without just compensation. That cuts both ways, I think. I mean, really, the strongest argument was the Second Amendment argument, because then we go down to the substantive due process argument, essentially that the law is void for vagueness. I don't like this law, but I read that law. It's not void for vagueness. I mean,
No.
it's pretty clear. So that last one was pretty weak, but really, we all know the plaintiffs should have won on Second Amendment grounds. They shouldn't have needed to even make those weaker arguments. And yet, of course, the judge didn't buy any of them.
This is something that we are going to have to continue to monitor, because this is the play. This is the play out of the playbook. But we hope you enjoyed this discussion. If you did, subscribe, hit that like button, and help us fight the anti-2A algorithm by sharing this video.
And pay a visit over to our friends at Core Essentials. Check out their fantastic gun belts. It's a great product, and they show them some love. They help make our content possible. Until next time, we're the Armed Attorneys.